Thank you so much, and thank you to Michael for providing commentary. We're running a bit behind, and obviously we're going to get drinks and dinner after this. We're standing in your way, so Michael has promised to only go for 5 minutes and only say the good stuff about the paper. At least that's what I anticipate. Well, let me say just a few things about by way of introduction to the executive power parts of the project. There's a chapter, chapter 5, where I sort of canvassed the debates over the meaning of executive power, and there's the three sort of conventional views in the debate. Is it a residuum of power? Does it merely identify who is to exercise the subsequently enumerated power? Or more recently, a lot more scholars have been arguing it is a substantive grant of power, but just of the power to execute law. In that chapter, I make the claim that that's the right answer, that there's no residuum, it's just the power to execute law. And what I try to show in the debates at the convention, the scope, this is all well known, the scope of the president's power was intimately connected to the question of whether the president was going to be unitary or plural. And so, when everybody says, oh, unitary executive, that's so scary. No, the whole point is they agreed on a unitary executive precisely because they thought they were carefully circumscribing the president's powers. And that is one of the points I make in rejecting a residuum and advancing this view of the executive power as being merely about law execution. There is a debate, of course, over that, and then I have a couple chapters about appointment and removal, and I won't bore you with it for more than just a few seconds. I have a somewhat more modest view. I think the president can remove at least principal officers, though I argue that the president does not have a constitutional right of control and instruction and direction. The president could always remove, but there's a higher political cost that comes along with that, and I try to defend that, and I think it's the most plausible reading of the opinions clause. And then I get into these chapters about emergency power and the framework of thinking about it, and I just end up rejecting left and right things like historical gloss, this idea that there's a piece of the United States and that the president can enforce without a statutory basis, and I just don't think there's any emergency powers. I think Youngstown Category 2 is conceptually totally incoherent and is an invitation to emergency power when they purportedly denied the existence of emergency power in that same opinion and in other opinions in that case. I think the way the framing generation probably treated emergency power was that, of course, the president could act in an emergency. It didn't make it constitutional. Right? So you don't have to try to square everything presidents have done in emergencies into your understanding of executive power. And so I guess what I'm trying to say is the more and more I think about executive power and read about executive power, the less of it I think there is, just as a formal constitutional matter. And it turns out that that's sort of what I think in the foreign affairs and war parts, but it's a bit more complicated. So what are these chapters trying to do? Well, the puzzle that these chapters try to address can be sort of described as the laconic puzzle. Is the Constitution laconic on foreign affairs? On the one hand, everyone seems to agree about this. The formalists, more formalists, tend to say, yeah, it's laconic. It doesn't account for all of these things, instructing ambassadors, recognition, executive agreements, and so you need this residuum. And functionals say, yeah, it's laconic, and Congress and the president will fight over it, and then you have historical gloss and historical practice and so on. And my claim is that both of these views risk leading to an aggrandizement of the presidency, an aggrandizement of executive power. It doesn't mean they're wrong about their particular claims that the president could do X. It's just that their methods, both formalist and functionalist, are easily amenable to presidential aggrandizement, and that is what I'm pushing back on. And so I do it, I think, in two principal ways. The first is to say that I don't think the Constitution is laconic on foreign affairs. All the principal foreign affairs prerogatives from Blackstone are assigned somewhere in the Constitution, and you just have to give them. So it makes it implausible, I think, to think that there's something missing when all of the principal prerogatives from Blackstone were, it's possible, but just implausible. And I think a proper interpretation of them solves a lot of these puzzles, like communicating with foreign nations, instructing ambassadors. I mean, ambassadors managed relations, and the whole argument I made about removal, appointments and removal, which I just previewed, I think explains how the president can instruct the ambassadors, and I don't really think instructing is a power. Anybody could communicate. Anybody could bark orders. The president could order the Secretary of State to go fetch his or her coffee. That's not a power. The real question is whether the officer has a constitutional obligation to obey. And that, I think, is just sort of reframes it in a more interesting way, and I think once you recognize that ambassadors can manage and the president can always instruct and remove if there is disobedience, then I think that solves a lot of these missing powers. I also make a claim about the treaty power, that you have to treat in order to make treaties, and who knows what parts of treating and negotiating and managing relations might lead to a treaty. So it just seems weird to say that these powers that scholars have said are missing are actually missing. They seem to fit quite comfortably, if you ask me, in the ambassadorial power and the treaty power. And the second point is, even if that's not persuasive, or in addition to that point, which I already hinted at, is that I think a lot of what presidents do just isn't power in any constitutional sense. A lot of it is just talking. It's just talking, right? The president can announce whatever he or she wants, and then whether he or she can make good on it depends on the Constitution's distribution of powers. Easy case, everybody seems to agree with me about this, is the Monroe Doctrine. And so I start with that. Monroe could declare whatever he wanted with respect to European interference in Latin America. That didn't give him the power to make good on that threat. Only Congress could declare war, only Congress could abrogate treaties. The harder case, but I am 100% right about this, even though everyone thinks I'm not, is the Neutrality Proclamation. I mean, no one has been able to point out to me how the Neutrality Proclamation had any legal effect whatsoever. And so, of course, the president can articulate his view of the law of nations in a proclamation. Nobody in the courts cited the proclamation. They cited the treaties. They cited the law of nations. There was even a South Carolina district court judge in the instructions to the customs collectors. There was a case, and he says, well, I can't take notice of the president's proclamations. Like, I will interpret the law, including the law of nations, which is interesting. There's, of course, the Gideon Henfield prosecution. I think the same thing can be said of recognition. I just don't see how that's a power. It was, certainly at the time the Constitution was written, recognition of foreign states was not a constitutional power. And to the extent it was, the only implications that seemed to follow from it was the recognition of ambassadors, which is exactly the power that the Constitution grants. So it seems to me that the different branches of government can recognize or not for their purposes. So to put it another way, today that there is a power under international law recognized to be recognition of foreign governments doesn't answer the question of, okay, who under our constitutional system has the power to affect all of those things that recognition affects under international law? That's just a question of our constitutional distribution of power. And on this point, let me just say how not to do this analysis, and it's United States v. Pink, which got everything wrong. It said the president has this inherent recognition power to recognize the Soviet Union, as part of that to create an executive agreement without any sort of statutory authority, and that the executive agreement is supreme law of the land under Article 6. That's triply wrong, right? So I just don't see I just don't see how any of that is compelled by any sort of reading of the Constitution. Executive agreements is similar, I just mentioned. Just talking. Whether the president can make good on what he promises to Iran depends on what powers Congress has delegated to the president. And so I just don't I see executive agreements as an exercise of power in and of themselves. So all of this is just a way of saying, I think you can explain a lot about presidential power in foreign affairs without resorting to the residuum or functionalism. I'm running out of time, so I won't say anything about the war powers other than I think I've solved them.
So let me begin by saying I'm delighted that Ilan is doing this book. By the way, we're going to have some disagreements here, I predict, but there's probably no one whom I agree with on more things in constitutional law than Ilan. He just happened to produce the chapter in the book that rubs me the wrong way. But I love the book. I'm only going to talk about the foreign affairs portion because there's only one tiny detail in the war chapter that he and I might talk about, and it's really in the weeds and doesn't matter very much. Many of the conclusions that Ilan has about the foreign affairs power, I also agree with. What I take issue with is his general framing, which I think goes to issues that go well beyond the foreign affairs power. So Ilan sets this chapter up with a debate between two sets of scholars, and he says they're both, I'm in one of those sets, he says they're both wrong, and that he has this new idea that solves all the problems in a better way.
Classic Ilan move.
Maybe it has the virtue of novelty, but not the virtue of coherence or persuasiveness. His basic idea. So first, I'd like to explain what my view is, and it's not just mine, but it's the vesting clause view, because the chapter portrays it, and he always calls it the residuum view, which of course residuum is not a word in the Constitution, makes it sound as though this is some sort of a functionalist thing that says the president must have these residual powers. In fact, it's an entirely textual and historically backed position that the vesting clause, the executive power, refers to powers of an executive nature that were not allocated elsewhere and that were not limited or circumscribed by the rest of the Constitution. Where does this come from? Well, the very beginning of the Constitutional Convention, Virginia Plan, Resolution 7, provide that the executive is vested with the power to execute the laws and the other executive rights that have been vested in the Congress under the Articles of Confederation. Now, I submit that we know two things from the wording of this provision. One thing that we know is that there may have been some dissenters, but at least a very substantial group of people believed that the word executive and the word legislative had some content. By the way, that's the executive, the legislative rights of the Articles Congress in our Congress. So they thought that these words had an actual content. They are not mere placeholders for whatever powers you pour into those two branches, that they had real content that you could tell the difference. How do we know that? Well, if you look at the Articles of Confederation, there's not a list of executive powers and legislative powers. It's just a list of powers. And so to be able to tell which of those were allocated in the executive and which are allocated to the Congress, you have to make some judgment, which are executive and which are legislative. And of course, on the boundary between those two things, there are going to be some close calls. There are going to be some fuzziness at the boundary. But fundamentally, these words, executive power and legislative power, had some actual content, probably derived from some combination of history and political science. That's point number one. Point number two is that the executive powers go beyond the power to execute the law. How do we know that? Because Resolution 7 gives the executive the power to execute the law and the executive powers that are vested in the Congress by the Articles. Note that executing the law was not one of Congress's powers, because the Articles government did not have the power to enforce the law. That's one of the main reasons why we needed a new constitution. The states executed the law, right? But now the execution of the law plus the executive rights that were vested in the Congress under the Articles are to be in the new executive. Immediately, Charles Pinckney leaps to the conclusion, oh, that must mean the powers of peace and war, and that sets, nobody disagrees with him about that, but everybody thinks it's a terrible idea, because vesting these powers in the new executive would make a president who's just too powerful. So they reject Resolution 7, and it's not until a month and a half later that the Committee of Detail constructs what we now have as our executive. They solve the too powerful a president problem, or at least they think they do, by allocating many of the executive powers to Congress, eliminating some of them for the federal government altogether, and even with respect to those that are left to the president, to whittle them down in various important ways so that they are less dangerous, have less of a scope than they had under the Blackstone's description of the British Constitution. So having made the presidency safe, they then create a vesting clause and say executive powers are that, and at this point, what they mean by that is powers of an executive nature not assigned to Congress and not whittled down, not subject to qualifications like advice and consent elsewhere in the document. And that's basically what we have. I'm going to talk about this a little bit more later, but this reading of the Executive Power Clause is endorsed by three different important congressmen in the first Congress. It's endorsed by Madison, it's endorsed by Hamilton, it's endorsed by Jefferson, it's endorsed by Jay, it's endorsed by Washington. That is a pretty powerful historical case that this textual interpretation of Article 2 is correct. So that's the position that Ilan is arguing against. Ilan's position is that the foreign affairs powers can all be deduced from the three powers explicitly given to the president: the power to appoint ambassadors with the advice and consent of the Senate, the power to make treaties with the advice and consent of the Senate, and the power, which is actually a duty, the duty to receive ambassadors. He calls this a purely textual argument. I think it doesn't work. There's quickly as the problems with this that he doesn't even address. Appointing ambassadors, they use that word instead of the broader term sending ambassadors. And to appoint a person does not give you necessarily, doesn't give the appointing authority necessarily the power to instruct or to control their operations. Presidents appoint judges. That does not mean that they can instruct judges. The power to instruct does not textually follow from the power to appoint. But more importantly than that, the power of appointment is subject to the advice and consent of the Senate. So what Ilan says is that what he says is the power to appoint ambassadors covers much of the necessary ground. That means to be able to supply explanations for the foreign affairs powers. Well, if that's where they come from, can the president exercise any of them directly, not through ambassadors, not through officers subject to the advice and consent of the Senate, but directly? Can he, for example, pick up the phone and talk to a foreign official? That plainly doesn't follow from the power to appoint ambassadors. The power to appoint ambassadors is subject to the senatorial control. If we really thought the foreign affairs powers were derived from the appointment power, we would be saying that the president's foreign affairs powers are all subject to the Senate's authority. He doesn't really argue that the power to receive ambassadors amounts to much in this particular context, but please note the power to receive, even if we put aside the fact that Hamilton in the Federalist Papers calls this more a matter of dignity than of substance. I think he changes his mind about that later, but it has to do with who is going to be the instrument for reception of the views of foreign nations. It isn't about who controls American policy toward foreign nations. So I don't think reception power has much to do with it. As to treaties, much of foreign affairs has nothing to do with treaties. I don't see how you can possibly think that as a purely textual matter, you derive the foreign affairs powers from the treaty power. Now, on page 21, Ilan points out, quite accurately, that you could do a treaty about everything, and therefore he says, maybe I should quote it because you won't even believe that I'm.
It is not far-fetched to suggest that everything the president. That line.
It is not far-fetched to suggest that everything the president or ambassadors do with respect to treating with foreign nations might lead to a treaty and therefore falls within the treaty-making power. Since you could do a treaty about anything, that means that everything derives from the treaty power. I don't think we're looking at a purely textual interpretation. Moving away from text to history, this is where I think Ilan goes off the rails even more obviously. So he begins quite correctly with the dispute over the Neutrality Proclamation. Good place to begin. This was the first major separation of powers controversy over foreign affairs, and in it we have we know the written opinions of all the major players, basically, in connection with this. So Hamilton, page 5 of Ilan's piece, talks about this, and he admits that Hamilton takes the vesting power view. I mean, exactly the view that I take and that Ilan rejects. He says that Hamilton is the genesis of this view. That's actually not true. Jefferson had taken it before Hamilton. Madison had taken it before Hamilton. 3 other people in the first Congress had taken it before Hamilton. What Hamilton did is he explained it more carefully and more comprehensively than it had ever been explained before.
This is good. Keep going.
Ilan says he could have stopped there, but he didn't. He actually presented this theory. It does not go away because Ilan thinks it wasn't necessary to his argument. It was his principal argument. And what's more, Madison does not disagree with it. So, quoting page 6, both Madison and Hamilton agreed that the vesting clause, I'm quoting Ilan here, was a substantive grant of power. Madison disagrees with where you draw the boundary between executive power and other things. And then finally, he says that the Neutrality Proclamation did nothing. This is preposterous. The Neutrality Proclamation did some very important things. First of all, switching our status from being an ally of France under the treaty to being a neutral party, it increased American shipping's rights against the British. They no longer would be able to stop American shipping and confiscate American shipping on the ground that it was allied with France. It reduced American shipping's position vis-a-vis France because it was no longer allied but now neutral. It meant that America was no longer going to defend Americans abroad who were engaged in activities in support of France. Very important thing. And then finally, as Washington says in the proclamation, he authorized prosecutions against Americans who carried on belligerent acts against Britain. Now, and Ilan says that Washington purported in the proclamation to direct criminal prosecutions of individuals guilty of taking actions inconsistent with neutrality. He didn't purport to do this. This is what he did. And he brought the prosecutions. And the most famous one, which Ilan discusses at some length, is against Gideon Henfield. The jury acquitted Henfield. But we know why the jury acquitted Henfield. It's because they did not accept the theory that there is an unwritten federal law of crimes under the common law. The jury anticipated the position of the Supreme Court just a few years later, 1812, and the decision of Hudson and Goodwin against the United States, and which was orthodox Jeffersonian position. There are no unwritten crimes under federal law that can be prosecuted. That's what the jury did. Had there been, Washington took the different position, most of the Federalists did. Had there been a common law of crimes in which the law of nations would inform, because everybody agreed that the law of nations was part of the common law, the case would have exactly hinged upon Washington's proclamation, because what Henfield did would have been perfectly legal under the law of nations if we were allied with France. It was illegal under the law of nations once we are neutral between France and England in the law. And thus, for Ilan to say that this proclamation did nothing of legal effect, I think is simply false. And I'm going to stop, but I'd like to note that this is not the only foreign affairs controversy in the early years in which the vesting clause theory was relied upon by Jefferson, Madison, Jay, and Washington to justify executive actions. So what we're left with is a purely textual argument that really doesn't carry the day textually, that is contradicted by every framer, every founder who speaks to the issue. I think, Ilan, you should go back to the drawing board.
There may or may not be any divergence between Ilan and Michael on this, but it falls to me to a point, though not necessarily to instruct Ilan to respond.
Yeah, so I think there was something useful in there, but Michael is wrong about almost everything he said. And I'm going to try to explain why in 3 minutes, though I'm not going to succeed. I'm going to try to get as far as I can. The dispute is not over whether, between him and me anyway, whether the executive power clause has content. It does. Madison and Hamilton did agree on that, but they disagreed about what that content was. Madison did not adopt the residuum theory. That is a common misconception. He adopted the view that the executive power included the power to oversee the execution of the law, and that that power may have included appointment and removal. He did not think that that included other powers historically exercised by the monarch or that could have been, were executive in nature. So as for Hamilton, yes, he made the argument, admitted it was unnecessary. He was a good lawyer. Jefferson's comment was in the context of ambassadorial appointments, and yeah, that's some evidence against me. Not all of the evidence goes my way. I'm not sure the Washington and Jay statements, so I'd be interested in getting, so that's particularly helpful. As for the content being only the executive power, I should be clear that McConnell actually dislikes Chapter 5. That's what he's fighting with, the chapter trying to give you, okay? So something, in Chapter 5, Michael is right that they reject Resolution 7, but here's what they do adopt. Madison proposed to fix the extent of executive authority before determining how far such powers might be safely entrusted to a single officer. He moved, and the convention agreed that the executive shall have power to carry into effect the national laws and to appoint to offices in cases not otherwise provided for. That was it. That was the extent of executive authority when they decided on unitary executive, not all these other executive rights, but the power to carry law into execution. Now, of course, what does this appointment and removal has something to do with here? And I'm going to try to say one thing about this, which is about the appointing versus sending, and then one thing about neutrality, and then I'll stop. How does the power to appoint lead to the power to instruct or to remove? It's the same question that exists with respect to domestic appointments. Right? The Senate has a share in the appointment of those officers too. So how do we get so if Michael wants to say you need a residuum, okay, then I guess his argument would be that you need a residuum both domestically, that's fine. Okay? But here's the response against that, okay? Why did in his book, Michael says it is perplexing why the convention didn't talk about the removal power. It's actually not perplexing at all. Why? Because the accepted common law maxim was the power to remove was an incident to the power to appoint. Why? You just appoint someone new, and you displace the person with the new appointment. So until September 7 or September 11 in the convention, the Senate had the appointment of some officers, judges and ambassadors, and the president had the appointment of everybody else. There was no need to talk about removal because each department would appoint their own officers and remove through the act of appointing. It was only when in the last minute in the Constitutional Convention, they gave the Senate and the president a share in the same power that all of a sudden this problem arose. Well, wait a minute. If the power to remove is incident to the power to appoint, and now you have both of these institutions, do you need both of them to act in concert to remove an officer? And this is where the debate of 1789 came in, where Madison said, if the Constitution said nothing else about this matter, I would buy the argument that removal follows from appointment, and therefore both the Senate and the President together must do it. But the Constitution does say something else about it. It says the President has the executive power, which is the power of overseeing the execution of the law, and the President must have the ability to remove. That's the explanation for this, and it explains ambassadors as well. Just because the president and the Senate share in the appointment doesn't answer the removal question in the same way that it didn't. You can get there in the domestic sphere, and you can get there the same way that Madison, I think, did in 1789. Let me say one thing on neutrality, which is Washington declaring that we are allies of France, because that's what the treaties say, does not make it so. That's what Truman argued when he sent troops into Korea without congressional authorization. I think that was unconstitutional. The treaties may say X, but whether you say we must come to the defense of Korea. Okay, well, who gets to come to the defense? Who gets to decide whether we're going to meet our treaty obligations or not? Congress, which has the power to declare war. The president couldn't just make it so by saying that he believes we're allied with France under the treaties.
Very much appreciate the exchange, and executive power is not one of my areas of specialty, but I have a question as to whether there might be yet another intermediate position. So John Harrison's paper on executive power talks about the idea of sort of using the resources of the government. So if Congress, creates a public park and doesn't appropriates some money for people to run it, but doesn't really say anything more, presumably the president, in executing the laws, gets to decide, what's the park going to look like and where the flower's going to be and so on. If it's not otherwise apportioned and it's just left open, presumably that's in the hands of the United States to decide, and the president acting for the United States gets to do this. The same might be the case if, let's say by treaty, we're going to have a summit with Russia every year, and in alternating years, the United States and Russia get to determine the menu. If nothing else is specified, it just says the United States gets to determine the menu this year. Presumably the president, executing the laws, could either delegate that decision to someone or could do it himself, should he so choose. This matters for treaty termination, because my understanding is that a lot of treaties, especially the ones where the president first asserted such a power, just said, either side, the United States or Mexico, say, may terminate on notice of a year or something like that. So if the treaty has no termination provision and just is sort of permanent, then I think I would agree with you that it's supreme law of the land, so only Congress can override the treaty. But if it creates a power in the United States to terminate, can the president exercise that power? And is that something more than the execute the laws power that you see the president as having?
Will.
Ilan, I'm curious what you think about the law of nations, because the most sort of puzzling thing to me about this chapter is how little of the law of nations is in there and how much it's written as if you and the Constitution sort of don't think it's a real thing. So like a lot of the discussion of agreements, proclamations of neutrality, executive agreements as being just talk is sort of what my colleague Eric Posner would say. But I don't think the framers of the Constitution were like Eric Posner. And so the more natural question would be, as a matter of the law of nations, who has the power to change our status as a matter of international law? Does the Neutrality Proclamation have some status, or how does our status change? Same thing for recognition. It seems odd for the Constitution not to address these basic law of nations questions. maybe you think that's in the take care power, but since you don't think the take care clause includes the Constitution, I'm not sure you think it includes the law of nations either. So I'm just sort of puzzled about what happened to international law.
Ilan, very much enjoyed your paper a great deal, and I agree with 95% of it. But I do, when Michael mentioned the Articles of Confederation and the absence of an executive power, I quickly went to Federalist 15, where Hamilton does talk about there being an executive power. It happens to be military power, which is terrible executive power, but it is called executive power there. And he says that's the only thing we've got left now. The only form to execute the articles with a breach is going to be war, which suggests that that executive power does include war-making power, just war. The second point, which I don't know if you're going to disagree with me on, is, and I just wanted to throw out this theory, and I don't know how much it's ridiculous or not, but all this discussion of declare war, that war is declared. And I'm thinking about Roosevelt's request that he asked Congress to declare that a state of war has already existed. That what Congress is doing is taking obscurity and making it clear. And that's not, and so you could flip your chapter up and say, look, can the president as commander-in-chief at Pearl Harbor, can he order them to shoot back? Of course he can. Because it's the very nature, human beings have a right of self-defense, and you don't need to talk about a power to fight. What's needed with the Declaration is actually to take obscurity and make it clear, and then, as you said, to make it public. The whole public is, at any rate.
Ilan.
Great. Let me seize. I think I agree with the last point. I think it supplements, complements the arguments I make about the declare war. Your first point about war making and treaty making, I didn't catch exactly, but what I would say about that is that's another disagreement between me and Michael, where I think he interprets James Wilson as saying that they were not, that they were executive in nature. Or maybe I'm misremembering exactly, but I think he said that they were legislative in nature, and that's the same thing that Madison argued, and so that's my view on the background principle of war making versus treaty making. It's true that the executive as an institution in Britain had exercised those powers. It doesn't make them executive in nature, which is you have to be very careful as how you're using the term executive in that sense. Well, the law of nations is real. The question is who gets to decide what it means and who gets to enforce it. And I don't know that the law of nations has had an answer to the question, but if it did, the question of who gets to decide what the law of nations is, the Constitution trumps that. So, for example, the judges interpreted the law of nations and the treaties for themselves in Henfield's case and the prosecutions that were brought. No one relied on the proclamation. The law of nations enjoined the nation to give compensation when belligerent rights or neutral rights or were violated. And so the French, or was it the British in this case? The British demanded compensation because some Americans were violating the neutrality. And under the law of nations, King George probably could have given compensation if someone had asked him, but Washington in that letter said there's a difference between their constitutions and ours. Congress under our Constitution has to be the one to make good on whatever obligations the law of nations imposes because they have the power to appropriate. So that's what I would say about that. Steve, I don't know about John's. I think you need I don't know if resources is any different than any other law. I do think as long as, so for example, I don't think the president could just do whatever he wants with the public resources, with the public lands. Of course, Congress has the power to make rules and needful rules and regulations, right, for disposing of the public lands. So, if it means like I'm the current possessor of it, I'm going to maintain it, but not otherwise do anything. I suppose, which would just be in faithful execution of the Constitution's assignment of this question to Congress, right, until Congress acts in that sense. But with respect to public property or any other thing, you need to wait for a statute, I think, and then the default is that the president can personally execute, unless the statute assigns the duty to someone else, then I think the default is not. I didn't address every single point, but.
I have a question about this line, Ilan, which relates to some of the debate that you and Michael are having about the neutrality declaration. So you you say, this demonstrates once again that anyone can talk and the president has the loudest megaphone, but whether anyone can make good on what one says depends on the Constitution's particular distribution of power. And then when you responded to Michael, you used a historical example and said, just because the president says something doesn't make it so. And you used an example, I think, a president declaring wars and said, I think that's constitutional. And I just want to point out, I think those are two different things. Like, it might both be the case that a president is making it so as a legal matter, like it has legal force and effect, and it is constitutional. So saying it's not constitutional doesn't actually negate the point that saying it made it so. And so like a hypothetical question I have for you is, what if a president said, I'm declaring today that the established church of the United States is, pick your favorite denomination, I don't care. No one has to comply with anything, there's no obligations. It's a benign establishment. But like, aren't there some cases where the Speech Act alone has legal significance, regardless of other things that follow on, regardless of whether it's constitutional or not? Because you might both think that Speech Act is unconstitutional and that it wasn't the president just talking because he happens to have a loud microphone, but there was something legally significant about that.
Judd.
So I'm interested in a piece of this chapter relating to the recognition power, but then also more broadly, the other distribution of powers questions that you talk about in the introductory chapter. It seems like you have a kind of recurring theme throughout a lot of different pieces of the Constitution of looking at powers as sort of discrete means and recognizing that those exist independently and not requiring the possessor of one power to respect the policy choices that are made or might be made by somebody else holding a different power. So this arises in the context of recognition. You have the potential here for conflicting policy choices by different actors. And so you sort of reject the idea that there is such a recognition power. And then it comes up in some of the other chapters with respect to things like the taxing power and the question, or the spending power and the question in Butler, like the second question in Butler, right? The ability to use means to achieve ends that maybe you would think are within the police powers. Also comes up in your embrace of the Holmes dissent in Hammer. And so my question is, I think that's really interesting. Like, do you see that as a kind of overarching view of how separation of powers works vertically and horizontally in the Constitution? And where do you get that from? Like, what if you do see it as a big overarching way of thinking about distribution of powers, is there some way of grounding that in the original understanding of particular provisions, or more generally of just like the way they thought about the distribution of powers? I don't think a lot about distribution of powers questions. I vaguely recall debates over this sort of thing coming up in the Jade Treaty debates, where they have a debate about whether the policy choice made to enter into a treaty necessarily binds then the appropriations decision that Congress has to make. Of course, that has law of nations overlays, but then they have a very similar debate that happens with respect to the mint. I don't remember the details of this. It's been like 10 years since I read these debates, but the basic idea is, like, does the appropriation decision necessarily have to rely on somebody else's exercise of power previously? And people come out different ways in those debates, and so I'm curious, like, why it is that you come out one way. I'm also curious if you think there are any provisions that don't work like that. The only one I could see in the chapter was the police power, which maybe is different because it isn't a means, it's like an all-encompassing thing. So, thanks.
Larry Solom.
Yes, thank you, Ilan, and thank you, Michael. I've learned so much, Michael, from your work on these issues, and I am immensely grateful. So, Ilan, I have a suggestion, but I don't know exactly how the suggestion fits into the rest of the book. So the suggestion is this: there are competing theories about the meaning of legislative power, executive power, and the relationship of those categories to the prerogative powers. And I think it would help sharpen the chapter if at the end of this chapter, you've laid out a bunch of evidence, you were to explicitly lay out the alternative interpretations and, sort of summarize the reasons why you adopt one interpretation over the other. And so questions that I have that I think you could lay out clear and crisp answers to include the following. Are the prerogative powers powers that would have been executive powers or legislative powers, or is the category of prerogative powers a category of powers that were neither legislative nor executive in nature, right? And then I think it would be very helpful. So Michael's view is that the executive power includes the power to carry the law into execution, but it includes these other powers that are executive powers, but not carrying the law into execution. So I think it would be helpful if you charitably laid out that interpretation and then, sort of summarized your evidence as to why you believe that interpretation is incorrect. This is not really a question for you, Ilan, it's a question more for Michael. I'm very interested in what determines the content of the other executive powers. And Michael, if I understand you correctly, the answer I think you hinted at, or perhaps this is your answer, is that the content of the other executive powers, the non-execution executive powers, is determined by a combination of political theory and history. So as I understand it, then your position would actually could be restated as this is an open textured concept, and that some things are clearly in, some things are clearly out, there might be borderline cases, but that it doesn't have an essential conceptual structure. That is, there's no set of necessary and sufficient conditions, conceptual conditions, that define the category.
So in reverse order, Chapter 5 does a lot of that. So but having said that, prerogative power is tricky in two senses. Locke used it in a very different way than Blackstone, for example. Locke said prerogative was basically the power to act beyond law. Blackstone defined the king's prerogatives as his powers to act. So I'm treating Blackstone's use of prerogative as sort of the standard view that I think most of the founders shared when they were doing this, but as terms which were legislative and executive, I think that's the whole problem. They thought some of them were legislative and should be taken away from the king and given, which is why they enumerated the powers of Congress, despite Resolution 6, right? And this is a Kroski, I don't know if discovery, but I mean, he certainly first made the argument in modern times that's why, despite Resolution 6, where they didn't want to enumerate power, they ended up enumerating power anyway. Why? Because what do you do with all the king's prerogative powers if you don't want the executive to have them? You have to give them somewhere, and you have to give them to Congress and enumerate Congress's powers. And they thought they were mostly legislative in nature, and some were clearly they thought executive in nature, like the commander-in-chief power. And so they assigned that to the president. I'll let Michael sort of give his. Actually, can Michael talk to Larry's question before I do the other one, since it's related, if you have thoughts?
Yes, I do have some thoughts. I don't have a crisp and clear answer, but I have some thoughts. One of the most important things to do in trying to figure out what the content of this category is to look at the other two categories too, what is legislative and what is judicial. And on August 4th, Madison makes a motion I won't give the whole context here, but the important thing is giving the president powers and not in the way they put it is powers not legislative or judicial. I think that's very revealing that I think they had a clearer notion of what legislative powers are, power to pass laws, spend money. I mean, I think they had a pretty clear idea of legislative. They had a pretty clear idea of judicial. They had a much less clear idea of the content of executive, and that's why I think that history plays a big part of this. I also think that as a practical matter, as we look at these controversies, what it frequently is more important to look to see whether Congress has an enumerated power. At least under my theory of the vesting clause, not everybody agrees with this, but my theory of the vesting clause is that these are powers for the president to act without advance authorization from Congress, but not in the face of contrary congressional action. So Ilan and I both think that Zivotofsky was wrongly decided, and he probably doesn't disagree with this either. One of the most important points, and that Clarence Thomas gets wrong, and I don't say that all that often, is that Congress does have enumerated powers with respect to the passports. And so when Congress says you must put X on a passport, the mere fact that the president could, in the absence of that statute, take the other view, I don't think resolves it. That doesn't answer all of your question, but I think as a practical matter, in like 80% of the actual controversies, it'll get you pretty close.
And Stephanie, I don't, fair point, and maybe I should be clear about the distinction between those two things. One example might be Lincoln's suspension of habeas corpus, at least the second suspension over the draft riots. The first suspension, you can make a plausible case about convening, and I think the second one clearly had legal effect, probably unconstitutional. Those are different things. So I think I would say the same thing here. You know, the South Carolina judge said, oh, I can't take notice of what the president thinks the law is. If the judge did do that, I think that's a violation of the judicial duty. Probably. I probably would think something like that. So so I don't think it had legal effect. But to the extent it did, or could have, I think that might have been unconstitutional. Judd, there's a lot there. So let me just say kind of what I want to say, some of which will be responsive to. I do think there's a parallel I try to draw between the federalism, and the horizontal separation of powers. I don't know if I would call it concurrent power. I do think, and there's this chapter on the legislative veto that makes this very clear with respect to the horizontal separation of powers, and then the commerce chapter makes this clear with vertical separation of powers. I don't think these powers are concurrent. Right? I think Congress has legislative power and only legislative power. The president has only executive power. No one else has executive power, and the president has nothing but executive power. The court's judicial power. No one else has judicial power. They have nothing but judicial power. But each, in the exercise of their respective powers, can reach the same function, can reach the same activity, can be confronted with the same question. Some things only Congress will ever be able to do. Some things only the president will ever be able to do. Some things only the judiciary would ever be able to do, exercising their respective and exclusive power. But there will be many times when they each can reach the same question. It's just sort of like departmentalism writ large, in a way, right? The judiciary can decide whether Dred Scott was a citizen, and we have Professor Richard Primus here, and the Senate can decide whether Hiram Revels was a citizen, and decide to seat him. It's the same thing with federalism. My original conception of the commerce power is that it was exclusive. The power over interstate commerce was exclusive to Congress in the same way that the president has exclusively executive power. But the states had a different power, the police power, sometimes the exercise of which could overlap with the exclusive commerce power that Congress had. And in the case of the vertical separation of powers, there was a rule for solving the conflict in the event of collision. By the way, everything I'm saying, I think is what Marshall basically said. I think it's what Webster said. It's what William Wirt said in the debates in Gibbons v. Ogden. Though Marshall obviously didn't decide the point. But with the horizontal separation of powers, there isn't really a rule of decision. There's some rules of decision. Namely, maybe the president has some amount of power to do things that Congress does as well. Well, as soon as Congress does it, the rule is you take care that the laws be faithfully executed. There is a rule there. but it doesn't apply to all the separation of powers disputes. So I'll stop there.
Could I just throw something in with a concrete example? I think that some powers are as Ilan described. I think some are exclusively one or the other. I don't think we disagree. There's a really interesting concrete example of this in the Washington administration. The Senate took the position that it had the power to decide where we would send ambassadors. And the good argument for that, it's an office, they create offices, right? So, or Congress creates the offices. And Washington did not like this because he thought where you send an ambassador is extremely important to foreign. If we were, for example, to send an ambassador to Ramallah, that would be an extraordinarily important foreign affairs matter. And he consulted these his leading people, and I'm reading now from Washington's report of this. I'm not going to read most of it, but at the end, he's saying that the Senate's authority with respect to this extends no farther than advice and consent over who the ambassador would be, and he said all the rest being executive and vested in the president by the Constitution. So note that the language is clearly a reference to the vesting clause, and whether Washington is correct or not, we just toed it up. Oh, and he says, by the way, that he consulted with Jay and Jefferson in reaching that conclusion. It's it's one more piece of evidence that the vesting clause is actually a real thing, and that's where the foreign affairs powers really come from.
My question is whether this is really academic. I don't necessarily mean that in a bad way. It could be in a good way. But nonetheless, by which I mean it doesn't have a lot of practical cash out. Because it seems to me that you get largely the same place as the vesting clause theorists by having some aggressive interpretations of some other presidential powers. And you say that one of the shortcomings of the vesting clause is that it's subject to sort of exorbitant arguments. And you also say that one count against the vesting clause is that nobody objected to it, which nobody talked about the vesting clause as in the ratification debates. I mean, and that's if it were really a big grant of power, they would have. And that's perhaps a fair point, but it seems to me that both of these points also count against your view, in that if the specific grants of power to the president, like the treaty making, are actually extremely broad and give the president all sorts of communicative powers, then both things are true. Then that it seems like that if we're going to have very wide-ranging interpretations of specific powers, then that's certainly subject to exorbitant interpretations. And moreover, it seems to raise the same question: is that if those were actually the correct interpretations, why wasn't that discussed in the ratification debates? So, unless there's really significant space between the vesting theory and your theory in practice, and I know you have some examples, but I guess I'm not persuaded either that those examples are particularly significant or that those examples can't be reached by your theory. You say they can't, but I'm skeptical that they can't, because I've struggled to see what the limits of the aggressive interpretation of the text that you have are. So I guess maybe you could say a little bit more about why there is, if there is, why there is such a significant difference between the vesting clause and your theory and practice. Because I think if there's not, then that actually sort of counts against your view and for the vesting clause.
Yeah, can we talk for a moment about the emergency military powers? So you purport to derive the power to repel invasions from the fact that the president's commander-in-chief and he can use the armed forces when another nation initiates a state of war. But I don't think the Constitution quite speaks with that voice here, because there are there are kind of two types of military forces that the Constitution provides for. It provides for the regular forces and the militia. And even in the case of a sudden invasion, the militia clause requires Congress to authorize it. He has no inherent power to have access to the one military body that was guaranteed to exist. You know, the Constitution provides for the Army and Navy, it authorizes it, but it doesn't require the country to have it. And so, at least to me, it doesn't seem like there would be this inherent power of the president to repel sudden attacks, that the only military force that the country's guaranteed to have would require congressional authorization to use. And so from that, I'm not sure how you can derive that power from the regular forces and why the regular forces are different in this respect than the irregular forces.
I have two quick questions, and one is actually just, I had the exact same question as Professor Ramsey. What is the difference between substantively or at the cash out, what is the difference between your two theories substantively? If Ilan is implying all these powers from enumerated powers and then it's law execution versus yours that has the vesting clause reading or the residuum reading, what powers do you disagree about being in the Constitution and in the president? And then the other question is, did anyone, and this is more towards Ilan, but either of you, did anyone reject McConnell's theory at the founding? Did anyone say there is no residuum, there is no prerogative, the executive vesting clause does not contain anything more? I know there are a lot of people that said that it contained the power of law execution, but I don't know if anyone said there was no residuum. It seems like Madison in the Neutrality Proclamation said the problem with the neutrality, it was the powers of war making and treaty making, and therefore the residuum didn't come into play. But Hamilton said the residuum was beside the point. So Madison, like, it doesn't seem like Hamilton accepts the residuum, but Madison doesn't reject it in that debate. So does anyone actually say that Professor McConnell's theory is wrong? Any founder?
Ilan?
I think Madison does. I don't think he's articulating a residuum view, right? He's saying the executive power is the power. When it first comes up, which I genuinely believe is the Hamilton essay, Madison says, what are you talking about? Unless you can show that this is executive power, which he explained as the power of superintending the execution of the laws, then it's not, you want to call that a residuum? I don't know, I just call that executive power, which is the power to oversee the execution of the law. So I do think Madison denied it. I don't think, to the extent they talked about it, they weren't worried about this. And I do find that point persuasive of the dog that didn't bark, Julie Morrison, right? I think that's right. I think that's right. I think they would have said something if this was this substantive residual grant of power as opposed to just a substantive law execution power. I'll get to the point that you shared with Robert. With Mike Ramsey. Robert, why isn't the answer just that before you can compel people to participate in military anything, militia, defense, that's something that's more important. You need Congress to do it, and so you need Congress to provide for that. But to the extent that there is a standing army, why can't I don't see the two things as commensurate. Like there's an explanation for why the president would be able to use whatever standing army there is. It's true there might not be a standing army, but Congress might not have passed any law providing for calling forth the militia, I guess. Both are possible. I see those as two different avenues, one available to the president immediately, one available, assuming Congress has raised an army, the other available to the president, assuming Congress has provided for calling forth the militia. I think, so I guess that would be my view of it, but I'm happy to talk to you more offline. And I guess since we're out of time, let me just respond to the point of what's at stake here. One serious and one less serious. The more serious point, of course, is it's just a default safety mechanism, right? If you have the residuum view and you have a cramped view of legislative powers, that's risky. If you have the residuum view, but you have a robust view of legislative powers, then the differences between these things diminish, okay? I do think, for example, to answer what specifically would be different, I don't know, United States v. Pink, I think that's wrong, but can a residual theorist tell me why Pink is wrong? That the president has this free-floating recognition power and a free-floating power to enter an executive agreement. Okay, maybe it's not the supreme law of the land, that's obvious, but okay, I don't know. So there are some differences, but the stakes depend on how robust your view is. But generally, I agree with you. I'm just picking fights for the sake of picking fights, perhaps. And so I'll end with, I was on the airplane today for 4 hours, and I noticed on Grok there is a function that says roast me. And so I said, okay, let's just do it, roast me. And Grok looked, did its AI thing, and it said the following about me. Ilan, with your penchant for dissecting constitutional intricacies, one might wonder if you've ever found a legal argument you couldn't complicate further. You seem to enjoy the debate so much, I bet you'd argue with a stop sign for having too many angles. In your enthusiasm for engaging with students and peers on Twitter, it's like watching a law professor try to make fun happen at a lecture. Keep up the good fight, but maybe consider letting some of those debates go before you end up arguing with your own reflection in the mirror. And so maybe that is what is at issue here. So thank you for your comments and attention.